This meeting is a special meeting, I suppose, that has been called to discuss in the main two issues. The first one being a briefing, or at least let me say a briefing consultation with the Portfolio Committee by the Department of Communications and Digital Technologies, as well as BMI Technology Group, on the progress that's being made in the development of a funding model for the SABC. Then we have an issue around parliamentary legal services on the legal opinion on the 3.8 billion rand commitment that government had made to the post office. Let me thank you very much, members, for making time on a Friday afternoon. You will remember that we had submitted an application to the House Chair to be allocated additional time as a portfolio committee, as a lot of issues were running over and there was a lot that the portfolio committee needed to deal with, just in terms of the workload relating to the two departments and entities. We were allocated Fridays, and I think the decision is that we would use those Fridays as and when needed. And this was such a circumstance. You maybe let me, before giving a background to the items, let me just check if we have any apologies and whether we're correct to begin the meeting.
Good morning, Good afternoon, Chairperson. Chairperson, we have 6 members, and then we have an outstanding apology for Ms. Chauke Adonis. Thank you.
Thank you very much. I'm aware that Ms. Honorable Chauke Adonis has been taken ill, so hence that apology. Let me also welcome back, I didn't check the people in the meeting, but I'd like to welcome back 2 new members. Is it welcome or welcome back? Yeah, welcome back. Honorable Ndlela as well as Honorable Makubela to the Portfolio Committee as deployed by MKP. We received an ATC this week that was discharging Honorable Nchabeleng as well as Honorable Shongwe from the committee, and thus we have new members from the MKP. So if the colleagues are on the platform, it's really good to have you back, and I'm sure you will get on board as if you never left. All right, so then with there being no additional apologies and the meeting being correct, colleagues, you don't have to welcome me back, Mos, because we were together last week. Sorry, I didn't even apologize for that scene. We were together last week. Let me start with the first item on the agenda, which is the issue of the SABC funding model, and maybe just get some background before I hand over to the department to introduce their delegation. I received a call from Minister Malatsi early this week requesting that we do try and schedule. Hello, Honorable Chauke Adonis.
Apologies, Chair. I just wanted to notify the House that I am in the meeting. Thank you very much.
Excellent. Thank you. We're so happy to have you back. So I received this call from the minister requesting that we do schedule this special meeting just to meet with the department as well as the service provider BMIT on the funding models and the funding model or proposal. Honorable members will remember that for most of last year we were dealing with the issue of the sustainability of the SABC. And I think around August or September of last year, Minister announced that he had appointed this company BMIT, and they would require a period of 3 months to put together a funding model. The minister, of his own volition, has chosen to consult the portfolio committee on this development of the funding model. And I'm making that point because there's really no obligation, I think, to him at this point up until it appears before the portfolio committee. So we truly appreciate the minister taking the portfolio committee into his confidence. And our understanding is that on conclusion of the funding model, then the minister would wish that it is inserted into the SABC bill for finalization of that bill. They are on strict deadline, as I understand it, with today initially meant to be the day that their report is submitted. So sincere appreciation to the Minister, BMIT, as well as you honorable members making the time for this meeting. I have also received a correspondence from the Minister with regards to the proceedings as it relates to the presentation. The presentation is in two parts, as I understand it. The first part being Part A, which I think speaks to issues of methodology, of principles that have been taken into account. And then Part B is then the substance of the options that government is still considering around the funding model. The correspondence which has been shared with members was a request from the Minister that when we come to Part B of the presentation, they would wish that they are requesting Parliament that we go into a closed session. And that is because, firstly, as I indicated, the funding model is not yet complete. So they're not at that stage where they are consulting, taking it out into the public for discussion. And at this, I suppose, sensitive stage, they would want, just a consultation with members of Parliament around it. What that would mean if the committee approves in terms of the rules of the National Assembly is when we get to Part B of the presentation, we would firstly request that the meeting is not streamed, and then anybody who is in the meeting, not from either the department or the service provider or a member of Parliament and our staff would please have to excuse us at that point. We would go into the closed session, get Part B of the presentation, as well as the question and answer session. Then we would then reconvene back into an open session, at which point we would report high level, without going into detail on the issues that, we would have discussed in the closed session. Then we would proceed with the next item on the agenda. Then the second and final item on the agenda, I'm informed, has been requested by members, given the fact that we were having this particular meeting. And it's a request for the Parliamentary Legal Services to take us through the legal opinion that the committee had requested with regards to the National Treasury seemingly reneging on the commitment that they had made to court around the 3.8 billion injection into the South African Post Office. Members, that I think is really just trying to set context and in terms of the rules that Mr. Ngoma knows very well, to seek the concurrence of the Portfolio Committee on the proposal as requested by the Minister for a closed session. Maybe let me check if the Minister is here already or the Director General. If there's any additions that they would want to make to my presentation around their request, and then I will open it up to the members for a discussion.
Open.
Good afternoon, Minister.
Good afternoon, Chair. Good to see you again. And
sorry, Mr. Is that Honorable Ngobese?
Yes, ma'am.
Yes, Honorable
Thank you so much, Chair.
Sorry,
Chair.
One second. Sorry, Honorable Ngobese, you want to come in before the Minister? He was still on the item, and then I was going to open for the members after.
I'll come after the Minister. Thank you so much.
Thank you very much, Honorable Ngobese. Minister, you may proceed.
Thanks very much, Chair, and most importantly, thanks for the manner in which the request that we've made regarding this interaction has been handled. It's important for several reasons, but one of the things that we committed to around the development of a funding model for the SABC was to continuously provide updates to the Portfolio Committee. We did so when the appointment was formalized, and I think there were also two correspondences keeping the committee abreast of the various stages of consultations that were happening with different stakeholders. Because we recognize, one, that the Portfolio Committee is a key stakeholder in this process, we took the decision that it is important prior to finalizing the work that BMIT would be doing, that there is an opportunity with the committee so that the committee can make a contribution towards the formulation of the work that BMIT would be doing. And secondly, that of course, once that is done and all the stakeholders have been engaged, and as you correctly pointed out, there are other layers of consultation that ought to happen, culminating in the consultation that, as the Minister of Communications, will have to do with the Minister of Finance on one, the practicality of what would have been recommended as the options for those models, and also their synergy with the fiscal considerations of the current administration. And recognizing that because the journey is not complete, we felt that it would be appropriate that when we get to the section that deals with the various options that have now been distilled into few of them, based on the work that the team has done, that section be a closed session. We don't take that request lightly, Chair, because it is not a common request for the engagements to be closed, but it is done solely in the interest of safeguarding an incomplete process from becoming, the source of unnecessary engagements externally, so that the team can have the space to finish that work, having consolidated and consulted with each and every stakeholder. What the committee will have, which it always does in engaging with the business of the department, is when everything else is done in terms of all the consultations and we've decided on the option that we think is viable for where the SABC is now and taking it forward, that will also present an opportunity for engagement with the committee. What I didn't want is an instance wherein we have done consultations with any other stakeholder in the ecosystem, but not done so with the committee. So we appreciate the consideration that first the committee through your office, Chair, has taken about entertaining this request and leaving it to the members. And our plea would be to the members that the request is solely based on making sure that the integrity of an incomplete process can be protected, rather than any other clandestine attempt. We've always wanted to do this work with the committee and taking the committee along the various stages that we're in, and recognizing that, of course, in terms of the terms of reference, today is supposed to be the day in which BMT does the final report. This engagement obviously has an impact on that, but that's something that internally we will resolve. But we wanted to make sure that the committee, at the very least, interfaces with this before the final report is compiled, and that it can make a contribution towards that consideration. I'll leave it at that for now, Chair. Thank you.
Thank you. Thank you very much, Minister. Honorable members, I think that request is quite clear. And as you know, Rule 184 of the National Assembly rules allows you to take a decision in this matter. May I recognize Honorable Ngobese? Honorable Ngobese seems to be out of the meeting. Okay, may I check if we have any other hands? Honorable Bodlani?
Oh, good morning, Chair. Good afternoon, Chair, and good afternoon to the Minister and the meeting. Chair, I think we are all for open meetings because we work for the people of South Africa. But both of the explanation that yourself and the Minister have given, I am really inclined to agree to closing the meeting because of the commercial sensitivity. And Minister makes a point that moving commentary on the process will not help the process at all. So I am inclined to really agree to the request by the department, and to say for us, it should not mean that for future meetings that will happen, it should be on merit basis. So I'm happy to second the request, Chair. Thank you so much.
Thank you. Thank you very much, Honorable Bodlani. With Honorable Bodlani having moved that we go into a closed session for Part B of the presentation, may I call the next hand, Honorable Matafa?
Thank you very much, Chair. Good afternoon to you, Chair, and to the Minister and everyone on the call. Let me reserve my comments, Chair, and second the proposal by Honorable Bodlani in support of the proposals that you have made earlier. Thank you, Chair.
Thank you very much. I see Honorable Singh, your hand has gone down. So I assume that that was not opposing the proposal. Am I correct, Honorable Singh?
Yes, thank you, Chair. Greetings to you, to the Minister, members and officials. I was going to second, but it has been done. Thank you.
Thank you very much. With there being no hands then that I would take to read as opposing the motion, I think the meeting is unanimous that we will go into a closed session for Part B of the presentation. Minister, can I then hand over back to you and the department, if you could lead us and also please introduce your delegation. Thank you so much.
Thanks very much, Chair, and thank you to the committee for supporting this request. Chairperson, we are led from the department by the Director General and also the acting DDG on the branch responsible for media and content, Ms. Renailwe. The team from BMIT is led by Chris. I think it will indicate who are the other members of the team who are in here. So I think for purposes of openness, Chair, it will be useful that Chris indicates from the BMT representatives who are here, so that even when we get to the part of the closed session, the administrative staff can have a sense of who ought to remain in the meeting. So I'll ask them that next to their names, they indicate BMT, as some of them have already done. The structure would be that they would, Chris will lead the presentation on both parts. The department will complement in terms of additional input that we want to add if some key detail have been missed. But the department will particularly speak about the facilitation of the engagements with other government agencies or government departments, such as Treasury and also SARS, so that we can showcase to the committee that there's been those consultations. So how it will be is that, as you pointed out in the beginning, the first part, which is Part A, will speak to the methodology, will speak to the problem statement, and will speak to the approach that the team has taken in undertaking this work. And for purposes of clarity, when we get to the Part B, which speaks about the considerations around the various options and the thinking that went into it and what their preliminary views are on the pros and cons of each of those options, they will state that in advance so that those who need to be excused from this meeting can do so. With that, Chair, I'll hand over to the DG just to speak broadly on the intra-government consultation process, which has also involved the SABC, and that continued before Chris comes in and does the presentation so that there is sufficient time for members to contribute towards that. Thank you, Chair.
Well, thank you very much, Minister, and a very good afternoon to the Honourable Chair, honourable members on the platform, as well as then the distinguished delegates also. Chair, on the side of the department, just leading on from what the Minister has indicated, we've noted that this is a very important matter of which both Parliament as well as the general public have been extensively concerned about. With regards to ensuring that we find a funding model which obviously takes into account, I think, the comments that were made also from the parliamentary presentation as well previously, just to indicate that in the process of us developing this funding model, it was very important, considering that it does have a money bill implications. We consult National Treasury, as the Minister has indicated. We have held those consultations with them together with the BMIT, and I'm happy to indicate that other key stakeholders were also consulted. Amongst those will be then the SABC as well. So there are various options that have been there that have been developed, and part of those would also then require those engagements as well with those statutory bodies who have similarly had similar models. I mean, amongst those, as the Minister again alluded, would have been then SARS as well, and again, the National Treasury process. In the engagements with National Treasury, which was then facilitated, the National Treasury had made some strong emphasis on the issues with regards to the role of the public media, the need for us to ensure, obviously, the proper funding for the public mandate perspective, but also the need for the separation. And I think the bill, as it stands now, does separate the issues with regards from commercial to then the public mandate aspect. Honorable members, you would recall that at the time that we wanted to submit the bill as the department in 2021, our intent had proposed a housing levy, and that proposal of the housing levy was muted at the time by the National Treasury, owing to the fact that it would have also been difficult to sustain in the long term, and looking at also the other facilities or services that citizens would also be there would be expectations of similar. And as such, then that's when the department had submitted the bill with then the provision to then say to take 3 years for us to conclude on that. I'm happy that we've come back even before the 3-year period to then submit to you, and we would soon get into the proposals with regards to that. And then we've also had an engagement with the SABC, and I want to indicate here, respectively for the SABC, was just to seek further clarity because of the questions that were posed by National Treasury with regards to further emphasis as well as a clear definition of what public service media is. So I want to give an assurance that the SABC was not consulted as a beneficiary of this, but we consulted them purely on their role and in terms of then the significant emphasis on the public service mandate, and that was how we had restricted the engagements with the SABC. So we are happy then that we will be able to present to you the draft proposal, looking at the sustainable funding model for the SABC. And with your permission, Chair and honorable members, I would like to then hand over to Chris from the BMIT, who has been working with the department since September last year, and through to their timeframes, they have then honored that they would be able to provide us with then the proposal by the 6th of February. So with your permission, Chair, if I may, and Minister, may I then hand over to Chris, please, from BMIT.
Sorry, before you do that, DG, could I just acknowledge the presence of the Deputy Minister? My apologies. I did not see that he was in the meeting when I was acknowledging yourselves. You're welcomed, Deputy Minister Gungubele.
Chris, please go ahead. Thank you, Honorable Chair, and good afternoon again to the PM. Please unmute.
Good afternoon and greetings to the Chair, to the honourable members who are attending, to the departments and people that we've been working with who are on the call, to the Honourable Minister and Deputy Minister and the DG. and others on the call from the public. I just wanted to mention that I'm not able to share the presentation right now, so possibly someone could give me permission or access or use the one that's
You
been
can
sent
go
to me.
ahead, sir.
Thank you. Right, that's going to go up now. Great. So you should see the presentation on the screen at the moment, and I will remove my own face, but I will also introduce my colleagues. We've got Justine Limpet-Law, Brian Nielsen, Dinesh Balia, and Anita Matthews, and if he's able to join, Malusi Beloy. Put their names into the side channel so that you know to include them later on. Right, so we've been hard at work for the last 4 months or so, 3 and a bit months now, and we're really committed to it, and we're excited because we believe this is incredibly important work. I just want to confirm my screen is up for everybody. So I should be on slide 2.
It is, Mr. Good.
All right, so we want to set the scene, discuss the methodology and status, look at the conceptual model that we developed for overall funding improvement for the SABC, and then touch on our high-level findings before the actual model itself, and then hand back to the chair. So I wanted to make sure that we're all completely on board in the beginning, and many of you are familiar with this, but the absolute critical importance of having a healthy SABC supported by adequate and sustainable funding, and we've done extensive research and seen in all functional democracies, the public broadcaster, or what they talk about now in the digital era, the public service media, the critical importance of having it, and the independence is acknowledged. The social, economic, and political benefits have been documented, and they are substantial. And rather than becoming less over time, this is one institution which is becoming more important as we move into the era of increasing global conflict, where governments and other large entities are waging war through information media. And now you have synthetic media, which is not only misinformation and disinformation, but it's being generated through computers and, for example, deep fakes and automated media news attacks. So we also wanted to point out that one of our core findings was we looked holistically not only at the funding model, but how to unlock revenue and save costs. That the basis for the SABC, the mandate, which was very visionary in the 1990s, at the dawn of our democracy, and served well at the time, because of certain legal regulatory execution over time and the fact that it hasn't been updated, it's actually now providing invisible handcuffs to the SABC. The SABC has the 2 arms, the public broadcasting and commercial, and these are being unfairly, not the problem is not that they've held together, which is actually a plus for the SABC, but the fact that the movement is restricted. And so we've indicated in our report a number of areas where we see value being unlocked purely by changing the policy, law, and regulation. And I mean, such a good example was if you followed the autumn international rugby season at the end of the last year, where South Africa consistently did well and then went on to win. And it was very exciting for those who could afford subscriptions. But for millions of our citizens, it was actually quite amazing. They couldn't actually watch. And we so need in this country national cohesion, national pride, and inspiration to youth to watch people in action. So that was quite a obvious example of where those handcuffs need to be removed. Then when we looked at comparative funding, we noticed that most peers, South Africa, remember, is primarily advertising funded. Most countries are actually the opposite, if not almost all of them. They're primarily state funded, and this applies in all, across all continents. And we stand out for the low level of public funding. We're a real anomaly. And the trend, and actually, for example, in what's called the EBU area, the Europe and some of the Mediterranean countries, including North Africa, that the public funding portion is actually increasing relative to the whole, not decreasing. And in many countries, advertising by the PSM is actually banned or restricted, maybe only allowed during sports events, for example. So that's very much against what many people have been saying in South Africa. So that's a duplicate slide. This is the slide I want to go to, the methodology and status of what we've done. We looked at international best practice, and the report has extensive reviews. And we've drawn that into the discussion. We've had inputs from the stakeholder groups, as the acting DG explained in detail, but not only government entities for us, but also civil society, academics, and stakeholders that interact with the SABC. So that was, we had 2 sessions. Number 2, there is the initial session when we were getting fact-finding and gaining information, and then we went back to a few of them once we had some idea of what the models could look like for further discussion and engagement around the actual proposals. In the SABC, we've had various levels of engagement, from meeting with the board, meeting alone, meeting with the department, and meeting with ExCo and with individuals. So there's a lot more that could be done, especially given the 3-month time frame with consultation. I think there's still a process going to follow, to get society on board, etc. But this is the core consultation that's been done. The only small item that we would still like to get done in the next short while is to get more specific information from the Treasury on their tax policy experts. But otherwise, we're really grateful that you met today to close the circle in terms of the initial consultation for now. So we will deliver a updated version of our report, which is self-contained and has all the detail, by the end of today. And then we expect that the Minister will consult further with other ministers and relevant people. So we want to go back to just draw attention to how difficult this funding issue is in our society. On the left, I've got the main categories of potential funding. You've got households, which are more than 50% on grant funding. Around 25%, it's the primary source for the household of funding. You have individuals with high levels of debt and unemployment, especially amongst the youth. And then you have government, which is on a determined fiscal tightening, endeavor. And then we have a strong culture of non-payment, which applies, for example, in other areas like paying electricity and paying e-tolls, for example, and has also been seen in the license, TV license arena. And then not only that, but with electricity costs, power costs going up, that has taken some money out of the system that people did have over time, those going increasing. So the industry itself, on the top right there, you've got the SABC, which unfortunately there's this legacy feeling of a distrust, not by the SABC, but of the SABC, due to their involvement mentioned in the Zondo Commission, and the fact that the SABC is often seen as being one of many state-owned entities, many of which are failing and need funding. And that's a most unfortunate position for them to be in, that they are compared, because one, they have a different and a unique mandate, and secondly, they're not subject to some of the commercial failures, apart from the fact that they're underfunded for their public mandate. Now we have hard work for the minister, for the board, maybe for yourselves, for the executive at SABC to restore faith in the commercial competitiveness and viability of the SABC. Another issue which we noticed is that the value of the SABC, as much as it is less known to the middle class, if I could call that. I would say all of us. We are not the ones who tend to see the SABC or become aware of it as much as the millions of people who still watch linear TV, often rely on it. That's the only entertainment medium they can afford. But those people are on the millions and have a high regard for the SABC, and there's a high level of trust for the news at the moment. And then the final challenge is the industry, where you have a history of litigation. Fortunately, we see that there's a lot of plus side with the SABC. It's got a stable, experienced board now, going to midterm, 2 unqualified audits, possibly another one soon. The ExCo is very capable. The strategy is sound. You've seen it. You saw it recently. You saw the updates recently. The high viewership on some of the programs, they top the leagues in terms of viewers. High level of trust in the news. There have been surveys, put more than this in the report, but even last year they were the most trusted in one of the surveys, most trusted institution, higher than SARS, the Constitutional Court, others. And then significant focus that's coming through now with digital transformation, and the SABC doing very well with their digital subscribers. And fortunately, that also attracting the attention of the youth, for example, with watching sport and a couple of watching top programs like Ski and Psalm on the SABC digital platform. So that's really exciting. Collections have actually stabilized over the last 2 years, so not dropping as radically. And they've secured important sports rights. You saw the AFCON, now the Soccer World Cup, and world-class reputation in terms of running events like the G20. I saw some of the letters from some of the global diplomats who are very appreciative of South Africa engaging with the broadcast. We do note that countries have solved the problem of funding very differently, even though it's the same fundamental issue. And one has to ask why the solutions are different. Well, obviously there are different contexts, which we've taken into account, but there are also different value systems and value drivers, both with at the political level and at the level of the public. So we have listed in the report, and I've just highlighted a few. I'll go through them very quickly now because of time. But we need, and they can be weighted differently. And if you weight these differently, you come up with different solutions. It needs to be, independence is an issue across most countries, it's top of the mind. Needs to be adequate, stable, transparent, accountable, and that's in terms of the public and parliamentary oversight. Simple, so that everyone understands it. Enforceable, so we don't have the same problems as we did with the TV license. And in the process of execution, there has to be legal certainty. We need to know that we're putting forward models that are likely to be adopted and that won't sit in the courts. So we've taken this model, we've developed this, let's say, a taxonomy of all the areas where we believe policy, legal, and regulatory interventions combined could actually increase funds available to the SABC. So at the top, if you look along the left, I've got the categories. The first one was the commercial revenue sources. There are sources that could be unlocked by making changes to how they're regulated. There's certain cost management reductions, typically in costs, if the regulation was loosened without being as impactful. Investment in digital transformation. And then at the end, there are the different public funding options, of which we've listed 5. The null category on the right wasn't very popular. It was almost universally acknowledged that there needs to be public funding, and the innovative option, second from the right, we did look at, and we have recommended one of those, but they're not going to become the primary solution going forward because of the magnitude of the fund. And then we looked at various collection agencies, often in connection with the public funding option. So the SABC itself, the municipalities, SARS, the media industry, financial institutions, and other third parties. So that's quite a comprehensive analysis. Just to touch on what I meant, for example, with the first category, commercial sources, 2 of the main ones would be, and this top one is very significant, the must-carry regulations are where the SABC makes available to DSTV its 3 channels, SABC 1, 2, and 3. The mechanism for being remunerated for that has never been resolved, and that's going on for 12 to 14 years now. And that's an enormous amount of money that's been lost to the SABC, considering that those free-to-air channels are actually 3 of the most popular channels in the DSTV bouquets, actually. So they're not just incidental, they're actually primary. And in many cases, people take out subscriptions to get satellite access, but then want those specific channels. There's no deadlock breaking mechanism, and we feel that if ICASA applies itself and if there's sufficient discussion, this can be resolved. The second one is there are various other red tape restrictions which mean that SABC doesn't have access to certain funding or funding investment mechanisms for its content. And if those could be loosened, they could actually get more access to funding than they have now themselves. They wouldn't need to go cap in hand, but that would be automatically done. And I've given examples of some of those in that list. Then the next category was the cost management. This is where the SABC is able to reduce costs. This is a big issue around the world in the digital era. The one area on the left top there, I put loosen regulation. In other words, start from fresh in saying what regulation is needed for South Africa to achieve the public mandate outcomes, but which are not necessarily as onerous. The most obvious one is that SABC is regulated on a per channel basis with strict quotas per channel, whereas although the other broadcasters do have a couple of conditions, those are not per channel, those are per organization. And the SABC believes that themselves, and we support that even if one could develop general requirements rather than channel specific, one could even do more rather than do less, because there'd be more freedom for innovation. So that's the regulatory side, and there's more detail on that in our report. I'm just touching on a couple of items. And then the digital transformation is to take advantage of many of the digital tools, automation and AI being obvious one, digitization of content, to actually reduce costs over time. And there are quite a few examples that I could give of where this has already been done. It does require upfront investments in more modern technology to achieve this. Then finally, on this section, I just wanted to mention some principles around the quantum of funding. It's very important to know what the quantum is, because ideally it should be competitor neutral. In other words, it mustn't be so high that it gives the SABC what's seen as being an unfair competitive advantage. But it also should not result in an underfunding of the public mandate. So one wants to get that correct. We fully support the principle that the state needs to ensure guaranteed annual funding so that the SABC could execute. We have seen evidence in other countries of where merely the fact that there's funding uncertainty has led to decline in performance by the PSM. Without it, not the fact that it's been reduced, but surely the fact that there's been uncertainty. And certainly it does happen at the moment that the SABC has to spend a lot of management time, which should be focusing on executing on the mandate, thinking about where its funds are going to come from, the public funds. So it's very important to ensure in future guaranteed and stable. Then stakeholders that we did discuss all supported that principle. So that was actually quite strong support. And then based on SABC supplied data, and then we did our own analysis of that, and you all have access to the audited books which separate out at the moment the public commercial and public commercial service and public broadcast. Sorry, it should be the commercial broadcast service and the public broadcast service books. And we've given our view on the capex and maintenance requirements, and we believe the numbers that they've provided are plausible. And we also believe that if anything, you might have seen some of those numbers, but there needs to be more associated with the IT and technology transformation than was previously included. And there also needs to be one-off funding for the digital deficit backlog so that the SABC can get on track in terms of the right technology and the right technical skills and experience within the organization for a transformed organization. We do recommend that once all the decisions are made and the execution happens, there be another proper analysis with qualified financial analysts who have direct auditors with direct access to the SAP systems to look at the allocations, etc., in more detail at the time. But that should also only be after the mandate has been updated so that some of the costs are no longer applicable and within the updated policy framework. So it's clearer what the SABC would ideally be doing, what its true remit and vision going forward. So that's the comments on the funding. I just wanted to mention that at the moment, people on the call might understand this, but the books are maintained separately in terms of, although there's a lot of overlap with staff and there are a lot of allocations, some of the channels and radio stations are classified as public broadcast service, and some of them, like SABC3, are classified as public commercial. But in fact, when you look at how the channels deliver on their mandates, that is not the true breakdown. The true breakdown is between the activities, whether they're commercial or public mandate, rather than the channel. There are some public broadcast channels that are radios that are extremely profitable in their own right, and there are others that are commercial that aren't doing as well. So thank you very much. That concludes this section of our discussion, of my presentation.
Thank you. Thank you very much, Mr. Kretz. Can I check before then we go into the closed session if there's any additions anybody from the department would like to make relating to this part of the presentation? Okay, I take it not. So we are going to go into the closed session. I see that there's a message on the group, on the chat, that is requesting those who are not part of the closed session to please go into the waiting room I don't know how the waiting room works. Maybe the secretariat could just come into the meeting and guide us in terms of process. Mr. Ngoma?
Good afternoon to you, to the members, Minister, Deputy Minister, and everyone else on the platform. Chair will probably maybe request about 2 minutes just to move those who are not going to be part of the of this closed session to the waiting room. But we also request those that know how to navigate their way there to do so from their laptops. Thank you, Chair.
Are you not able to just tell us how it's done so that we don't have to sit and wait?
Chairperson, I see there's quite a few that have already moved from there. I'm not sure if from the participant side is done the same way. From my side, maybe they can use the 3 dots that pop up when you press on your name. I'm sure it should give you something like that, but we'll start moving people to the waiting room, those that we know of, or at least have named themselves properly, Chair.
All right. And then I know that the next item is supposed to be after this is supposed to be the post office. Maybe just to speed things up, I will ask colleagues who are here on post office business. They can move to the waiting room or alternatively log off. We will inform them when we are done with the SABC. The SABC unfortunately will also not be able to remain in the meeting. So I suppose that for now concludes their participation in this meeting. And then anybody else who knows that they should not be here, you can go to the waiting room or log off. I'm also requesting that Parliament TV and any other streaming service that is here cuts the feed on this part of the process, and we will indicate to them when they are back. So who we are expecting in the meeting are the members of the committee, the staff of the committee, the staff of the DCDT that has been delegated to be here, the Secretariat to get back the parliamentary streaming service, especially for the SAPO part. Chris, I have seen your message that you will be dropping off. It was just important that we close off in an open session. And to say that once again, we truly appreciate the engagement that we have had with the ministry, the department, as well as BMIT Knowledge Group. We do think that, this takes us some way in moving forward. Our common desire to see the SABC being sustainable, to see the SABC being empowered to participate meaningfully, not only in broadcasting, but I think in the digital future that they're trying to build, and the work that is being done towards the funding model is a huge step in that. We'll also look forward to the finalization of the SABC bill, because as we all know, this funding model is not going to really just, exist in the middle of a legislative lacuna. We look forward to the minister also giving us a sense of the timelines on when they will be ready to start the engagement around how that funding model is obviously incorporated into legislation. So while the portfolio committee was not asked, and certainly it's not its role to finalize the funding model, I think the various options that the government is considering, many of them viable, and I think what is coming through from the portfolio committee is that you should look at a hybrid sort of setup for funding of the SABC. I think also the members have raised quite sharply the issue of giving due consideration to issues of affordability, and I suppose a level of equity, while progressive in some cases, but a level of equity in terms of who bears the burden of cost. We've also appreciated to a large extent the international research that has gone into this, so that we are not just legislating, only for our South African conditions, but we take into account what other jurisdictions are doing across the world. So we do appreciate it. And finally, I think, that support from government, particularly the National Treasury, but all arms of state that may have to play a role in ensuring that this passes, is something that, this whole exercise is going to pivot on. So, Minister, thank you very much. Deputy Minister, the Director General, and all colleagues. I think we are done with this part of the presentation, so we may release BMIT. I'm not sure if the Minister and the rest of the team are staying for the discussion on the South African Post Office. Any last words, Chris, as you say goodbye? You are muted.
Thank you all. Thanks. It's been very useful for us indeed. Appreciate it.
Thank you very much. I'm sure we'll see you again when you have now finalized the process and you're bringing it through to Parliament formally. Thank you so much.
Right, we look forward. Thanks.
Thank you. Honorable members, then let's move on to the next item on the agenda, which is the legal opinion on the 3.8 billion injection into the South African Post Office. I may need to be guided here because I'm informed that you had discussed this sometime, I think in the last quarter, when this legal opinion was requested from Parliamentary Legal Services. I'm not sure whether it is coming back because it was never presented in the committee after you requested it, or if perhaps there's some issues that relate to that legal opinion that you wanted to engage on. So I will open for Member Bodlani. Honorable Member Bodlani, I understand you asked for the item to be added on the agenda. If you could please just give us a sense of the issues there. Thank you so much.
Thank you, Chair. Chair, my understanding was that the legal opinion was forwarded to the Portfolio Committee, but it was not officially presented where we could have an engagement with the legal services of Parliament. It was already on the parliamentary program. My request was just to bring it closer because it would then inform our engagement with the Post Office. So it was already on the proposed parliamentary program, But I think it really is a great opportunity for us to fill in the gaps that we might have identified as we were reading the legal opinion. And if my recollection is incorrect that we have not engaged it, then I do withdraw.
Okay, thank you very much, Honorable Bodlani. Honorable Subrathi, are you still on the call? I believe you would have chaired this meeting, maybe why we sought that legal opinion, and if you can just clarify if it has been presented, and then we can proceed with the presentation. Have we lost Honorable Subrathi?
No, Chairperson, I'm with you. I'm with you all. Yes, as Honorable Bodlani has indicated, we had requested clarity from the legal services about the obligation of Treasury to honor the 3.8 billion. Legal services did provide an opinion, which was shared in the group. It was, however, not formally discussed at a parliamentary committee level, and whilst it is on our program, Honorable Bodlani in the last meeting, I think, requested that we move it sooner. So Honorable Bodlani has covered me. I can confirm we did receive it. I think members would have read it, but we will look forward to receiving the formal presentation from legal services today, where we can engage them. Thank you, Chair.
Thank you very much. Honorable Bodlani, your hand is up.
Perhaps, Chair, I should wait for you to make a ruling on whether the item continues and then make my point.
Yes, Madam. No, the item continues. I think maybe I was being subjective there since I had been part of the discussions, but there's absolutely no reason why we should not take it. You may make your point.
My question and clarity. What we have today in front of the Portfolio Committee is a legal opinion from Parliamentary Legal Services. It is my understanding that we do have representatives from the Post Office in the meeting. I'm not sure what their role would be in relation to the Parliamentary Legal Services legal opinion to the Portfolio Committee. Perhaps if you guide us from the onset and we know how to go on with the interactions, would they be expected to express a view, or are they just merely observers? Thanks, Chair.
Thank you very much, Honorable Bodlani. So my understanding of this, and maybe let me commend the members of having taken the decision to seek a legal opinion in this, because I think much like what we were discussing before, it's about how do we ensure the financial sustainability of the entities that we have oversight over. The SAPO, the business rescue practitioners, have raised a number of times how the lack of follow-through on the commitment that had been made with Treasury has hampered their efforts of resuscitating the post office. Now, this legal opinion is to the committee. It is not a legal opinion, for government or anything of that kind. We wanted clarity on whether the minister can be held to account on the lack of delivery of the 3.8 billion. And obviously, in line with our role of oversight, whether there were any instruments at our disposal to compel him to comply with the undertaking that he has made. So I do want to reiterate that it is for the purposes of the committee. However, if in the engagement of the committee with the legal services, we have any need to clarify any issues with SAPO, they are in the meeting. I mean, it is an open meeting. They are generally observers, but should we wish to clarify anything with them, because they are in the meeting, we may do so, but it's not for them to respond. This is our opinion so that we take a decision on what we need to do moving forward. I think maybe in the same breath, let me also put it on record that a legal opinion remains that it's an opinion. We obviously take in very high regard Parliamentary Legal Services and the opinions that they give us. But at the end of the day, any action steps, whatever it is that the committee wants to do, it's still within its rights to do so, whether it agrees or doesn't agree with the opinion. Does that cover you, Honorable Bodlani? Please do come in.
It is my view that this is not an engagement with the business rescue practitioners or the post office, as it were. And I would like to canvass that the Portfolio Committee ask them to excuse themselves, because I don't know what they would be answering to, because this is us just receiving an opinion from Parliamentary Legal Services. I think we would be conflicting issues. even if we were to ask them for any clarity. We would be really putting them in a precarious situation.
Okay, okay. I did try to underscore that, it is an open meeting. There was no motion put forward for the meeting to be closed. So, as the chair, I don't have powers to ask them to recuse themselves until or unless the committee requires a closed session, in which case then we have not followed the same process or procedure that we did with the first initial item. Because when we received the request to close the meeting from the minister, we then wrote to the House Chair and the Speaker to be granted to be granted that leeway for us to close the meeting. They concurred, however, they indicated it was a committee decision. I do believe it's Rule 184 of the National Assembly rules that indicates that all meetings of Parliament shall be open to members of the public, to anybody, which would then include even people from SAPO. But I'm going to take guidance from the Secretariat whether the step of writing to the House Chair and the Speaker is in the rules, or if the committee can take a decision if it is convinced that that is the way to go. Mr. Ngoma, can you come in? Is there anybody from the Secretariat that is still here with us on a Friday afternoon?
Good day, Chairperson. It's Hajira here. Chairperson, previously we used to write to the House Chairperson and the Chief Whip and the Speaker. When I dealt with that issue in 2023 last, we had a closed meeting. I have conferred with, and this time around I've done the same. I've written to the House Chair, who's written back to say he's concurred and that basically it's up to the committee to decide. I've consulted with Mr. Ngoma, who knows the rules much better than me, Chair, and then he's indicated to me yesterday that according to his interpretation, we don't really need to write to the House Chair. If you look at NA Rule 184, where it states, for admission of the public, meetings are open to the public, but the chairperson or members may exclude such if the nature of which is such that it's confidential treatment or reasonable or justifiable in an open and democratic society. And further to that, the meeting would then just start, as you did previously, Chair, mention the rule, and the members would decide. That's my interpretation. I can be corrected by Mr. Ngoma if he's still on, because I see he is on. Thank you.
Thank you very much, Mr. Ngoma. Your hand is up before I go back to Honorable Botlani.
Good afternoon, Chairperson and members. Once again, my apologies for not having my video on. I'm having serious challenges here, Chair. Hence, I was quiet when you asked for the Secretariat because I would have missed part of what you had asked. But judging from Ms. Sally's response, all I can advise is that procedurally, in terms of the closure of the meeting, the committee applied NA Rule 184. That speak on the admission of the members of the public, and that rule was applied properly. And Chairperson, just on the issue of approvals and permissions, it's something that would have been done in the past, Chair, but we applied NA Rule 184, and as Hajira had indicated, even when she submitted that application, the response was referring us, the procedural officers, back to Rule 184. And just to remind the committee that when we were at the post office for the oversight visit, there was a similar request, and we had applied the same rule, 184. I hope to have responded to what we are asking. If not, please accept my sincere apologies. Thank you.
Thank you. Thank you very much, Mr. Ngoma. Before I come back to you, Honorable Botlani, let me just get the point of contention. Would your concerns be satisfied if the post office did not comment, they were merely observers in the meeting, or you wish to go into a totally closed session, which means that we would have to stop streaming, otherwise it defeats the purpose of asking them to recuse themselves. So if they only participated as observers, would that alleviate your concerns? Over to you, ma'am.
Thank you, Chair. Chair, I think you misheard me. My point was that we should not go into an engagement with them on what the legal opinion is, whether to fill gaps or whatever. So I'm not asking for a closed meeting, but what I'm asking is that we do not engage them on what the parliamentary legal opinion is advising. But I was saying, if there's not going to be any engagement, perhaps there's no point in them staying. But I was not in any way asking that you kick them out. But what I'm warning is that I don't think it would help the situation for them to come in and comment on a legal opinion.
Oh, thank you very much. Okay. Then I do apologize. I did mishear you. And as I had indicated, this is our legal opinion as the committee. I was only saying in the event we wanted any clarity on any matters, which then falls away. I'm happy to take that ruling that they remain in the meeting as observers. My apologies also to the team at SAPO. The intention is never to make you feel uncomfortable in any meeting of Parliament, but was really just to understand what the issues are. So with that being said, please, may I then ask, I'm not sure who's leading us. Is it Mr. Arnold from Parliamentary Legal Services? You may proceed. Thank you, Honorable Potlane.
Good afternoon, Chairperson. Good afternoon, honourable members, and good afternoon to all colleagues on the platform. My name is Adla Arnold, and I am from Parliamentary Legal Services.
We really love that picture, Ms. Arnold, of the beautiful Houses of Parliament, but I suspect if we had your face in it, it would look even better.
Chair, I thought you could see my face. Let me just see what's happening. I see the house. I am uncertain. Why am I not visible? Now, oh, there. Sorry. This is the face to the name.
Thank you, Madam. You may proceed.
Okay. Chair, may I put my video off while I'm doing the presentation?
No problem. Thank you.
Thank you, Chair. I just want to check, is it visible?
Yes, it is.
Thank you. Chair, honourable members, the CLSO was requested to provide legal advice on the outstanding 3.8 billion rand commitment. On the 3.8 billion rand commitment that the department made to the South African Post Office. Specifically, the question requested advice on the legal enforceability of this commitment and whether this commitment is a binding obligation in terms of any legislation. The issue of the 3.8 billion rand arose because of the business rescue plan, which outlines a two-tranche funding model. Firstly, a 2.4 billion rand was disbursed and utilized for retrenchment packages and operational stabilization of SAPO. And secondly, the 3.8 billion rand was earmarked for infrastructure upgrades, digitization, and settlement of statutory and creditor obligations. It appears that the SAPO business rescue practitioners have indicated that the lack of funding jeopardizes the implementation of the business rescue plan and may result in SAPO exiting the business rescue process prematurely. It is necessary to have regard or consideration of the factual background in order to aid us in answering this legal question. And while I thought it's necessary just to jog the committee's memory. So
sorry,
in February...
Can you put it your presentation in a slideshow in presentation mode, please? Thank you.
Thank you, Chair. So in February 2023, SAPO was placed under provisional liquidation. On the 10th of July 2023, SAPO was placed under supervision and in business rescue, and business rescue practitioners were appointed. During September 2024, SAPO briefed this committee on the anticipated what they termed day zero, which would occur in or around October 2024. As already indicated, the business rescue plan explains that 2.4 billion rand was approved by National Treasury and that the success of the plan depends on a further allocation of 3.8 billion rand. Through you, Chair, and I would just like to draw the committee's attention to page 69 at paragraph 8.9.1 of the business rescue plan. This paragraph explains that the business rescue practitioners anticipated that the approval process for the allocation of the 3.8 billion rand will be finalized during 2024 unless otherwise stated in writing. Here we highlight specifically that there will be an approval process in respect of the 3.8 billion rand, and this is captured in the business rescue plan itself. During October 2024, the anticipated 3.8 billion rand was not allocated to the SAPO when the Minister of Finance tabled the medium-term budget policy statement in Parliament. In March 2025, 150 million rand from the Department for Working Capital Requirements was approved by Treasury and received by SAPO. On 30 September 2025, the business rescue practitioners reported that because no funding was allocated to the SAPO per the MTPPS, austerity measures have been put in place by the business rescue practitioners. I now consider the legal framework in answering the question with regard to the 3.8 billion rand commitment. Section 213 of the Constitution provides for a national revenue fund into which all money received by national government must be paid, except money reasonably excluded. Section 213(2) of the Constitution provides that money may be withdrawn from the National Revenue Fund only in terms of an appropriation by an Act of Parliament or as a direct charge against the National Revenue Fund when it is provided for in the Constitution or an Act of Parliament. Section 214 of the Constitution provides that an Act of Parliament must provide for the equitable division of revenue. Section 215 of the Constitution provides for the national, provincial and municipal budgets. And then Section 26 of the PFMA provides that Parliament must appropriate money for each financial year for the requirements of the state. Section 27 of the PFMA provides for the national and annual budget tabled by the Minister of Finance in the National Assembly for that financial year. Now, the Money Bills and the Related Matters Act, Section 7(1) of the Money Bills Act provides that the Minister of Finance must table the national annual budget as set out in Section 27 of the PFMA in the National Assembly at the same time as the Division of Revenue Bill and the Appropriation Bill is tabled. Section 12(1) and 2 of the Money Bills Act also provides for the tabling of a national adjustments budget as envisaged in Section 30 of the PFMA with an adjustments appropriation bill. So the 2.4 billion rand payment, that is the first tranche, it was paid to SAPO in terms of the Second Adjustments Appropriation Act 2023, Act number 2 of 2023 specifically. So that is the framework within which we operate. So where does this concept of a 3.8 billion rand commitment come from? The 3.8 billion rand commitment or undertaking or promise or pledge was first made by Cabinet. Chair, honourable members, when we penned this legal opinion, we had not had the Cabinet statement in front of us, nor the referenced affidavits. However, we have perused them, and the Cabinet statement does refer to a 3.8, does speak to the fact that a 3.8 billion rand was included in the Cabinet submission when approved for when the business rescue application was granted, and as well as in court affidavits when application was made. Looking at the court affidavits, one can refer to paragraph 124 and 125, where the Minister confirms that additional funding will be sought from National Treasury, and Cabinet has indicated that it will support this application. So what does this all mean, and what is the intention of this intention to support the application for the additional 3.8 billion rand? If one has regard to the case of Minister of Communication and Digital Technologies and another versus South African Post Office and others, this is where the North Gauteng High Court, in consideration of the application of business rescue of SAPO at paragraph 12, found, and I will just read the highlighted portion, no objective reason exists to doubt the correctness of the evidence provided under oath, that is the evidence of the minister, that Cabinet has not only pledged to provide SAPO with the initially earmarked 2.4 billion rand, but also indicated its intention to support SAPO's application for an additional 3.8 billion rand in the October budget. The fact that there are conditions attached to the 2.4 billion is a consequence of SAPO being a state-owned entity. The undertaking, however, illustrates government's commitment to providing SAPO with capital and post-commencement financing to facilitate the institution's turnaround. So it is common knowledge that the 3.8 billion rand was not provided for in the MTBPS by the Minister of Finance in the October process. So what is the MTBPS? Section 6.2 of the Money Bills Act describes the MTBPS. It is a revised fiscal framework for the financial year in which the statement is tabled and the proposed fiscal framework for the next 3 financial years. It's an explanation of the macroeconomic and fiscal policy position. It is projections and the assumptions underpinning the fiscal framework. It is the spending priorities of national government for the next 3 financial years. It is a proposed division of revenue between the spheres of government. It is a proposed substantial adjustments to conditional grant allocation to provinces and municipalities and a review of actual spending. The MTBPS is often referred to as the mini budget. It is an opportunity for applications to be made by departments for adjustments to their budgets, apply for rollovers and request additional funds for unforeseeable and unavoidable expenditures as set out in Section 30 of the PFMA. The medium-term budget policy statement also sets out the policy framework for the budget that is presented every February and updates National Treasury's economic forecasts. From a policy perspective, it's important to keep in mind the Minister of Finance reasoning to refuse to pay the 3.8 billion rand. The reasoning, according to our research, are as follows. The Minister indicated a tough love approach has been adopted in response to state-owned enterprises. The Minister said there is an opportunity cost when you keep putting money into underperforming SOEs because you end up underfunding something else. Secondly, an option, according to the Minister of Finance, is getting private partners to invest in the post office. The second option, according to the Minister, is finding savings within the department to be able to bridge the gaps, but the department will have the final say. The Minister explained further, we are still working with them in making decisions around where and how resources can be shifted. So since money must be appropriated only in terms of an Act of Parliament, and keeping in mind that the 2.4 billion rand was appropriated in terms of the Adjustments Appropriation Act, Treasury is in fact entitled in terms of Section 4 of the Adjustments Appropriation Act to impose conditions to ensure transparency and accountability, effective management of the appropriation, and stop the use of the allocated amount if conditions are not met. This limitation as contained in Section 4 or empowerment as contained in terms of Section 4 of the Adjustments Appropriation Act accords with the Treasury's policy perspective that there are namely negative consequences associated with providing funding to state-owned companies without imposing conditions such as poor oversight on how the funds is used, misuse of funds, and the lack of accountability, frequently returning to government for more bailouts, and Treasury's inability to influence the required reforms or changes. Treasury has explained that there has been a realization that because of the limited impact post-government support, Treasury began imposing pre- and post conditions. The description of the 3.8 billion rand as a commitment appears in our view to raise the question whether liability attaches to the department. We note that Section 66 of the PFMA does provide for certain restrictions on borrowing borrowings, guarantees, and other commitments. However, Section 66 gives effect to Section 218 of the Constitution, which provides that national government, provincial government, or a municipality may guarantee a loan only if the guarantee complies with any conditions as set out in national legislation. And it is evident that this 3.8 billion rand is not a loan. The current situation is clearly distinguishable. In any event, Section 66, as read with Section 70 of the PFMA, requires a written concurrence from the Minister of Finance for a guarantee, an indemnity, or a security which binds the National Revenue Fund in respect of a financial commitment incurred or to be incurred by the National Executive. So in conclusion, any payment of money to SAPO will have to be done via an Appropriation Act. Specifically, the payment of the 3.8 billion rand would have to be done by an Appropriation Act. It is evident from the North Gauteng High Court and the Business Rescue Plan itself, in our view, that the payment of the 3.8 billion rand to SAPO was subject to an application to Treasury during the October budget process. Treasury has further expressed its view and rationale for its refusal to pay the 3.8 billion rand to SAPO. In our view, respectfully, Chair and honourable members, the 3.8 billion rand cannot, in accordance with our national budget process, as outlined in the Constitution and the PFMA and the Money Bills Act, be regarded as a commitment by the department attaching a legal liability. In our view, the facts present a scenario where the commitment made can be described as a tentative, provisional, conditional, or a non-committal. So I think it's evident that the 3.8 rand will not be forthcoming, or does not appear to be forthcoming. So what is our way forward? As this committee well knows, and Chair correctly pointed out, Section 55 of the Constitution, the National Assembly holds the executive account as well as exercises oversight over all organs of state. National Assembly Rule 227 goes on to say that portfolio committees may monitor, they may investigate, they may inquire into and make recommendations concerning any such executive organ of state, constitutional institutions, or any other body or institutions, including the legislative program, the budget, rationalization, restructuring, functioning, organization, structure, staff, and any policies of such organ of state, institution, or other body or institution. It's interesting to note that the oversight and accountability model adopted by Parliament defines oversight. Oversight entails the informal and formal, watchful, strategic, and structured scrutiny exercised by the legislature in respect of the implementation of laws, the application of the budget, and the strict observance of statutes and the Constitution. In addition, and most importantly, it entails overseeing the effective management of government departments by individual members of Cabinet in pursuit of improved service delivery for the achievement of a better quality of life for all citizens. It is evident that this committee has engaged with the department, with SAPO and business rescue practitioners on numerous occasions, and the committee continues to do so. The situation appears fluid with constant developments. In our view, the committee should continue to exercise its constitutional obligation of oversight. This could possibly involve further engagements by the committee with the latest developments, which appears to indicate the reported imminent strategic private partnership. Specifically also in relation to the business rescue plan, it may be prudent to ascertain the consequences of SAPO and creditors and the risk of liquidation or any other issues or matters as they may present to the committee. Thank you, Honourable Chairperson and members, and to all colleagues on the platform.
Thank you. Thank you very much, Ms. Arnold, for that presentation of the legal opinion. I think the full opinion, not just the presentation, had been circulated as discussed earlier. Members, do you have any questions, comments that you would like to pose to the parliamentary legal team? Okay, while members are still gearing up to go, Ms. Arnold, can you just explain to me, so if a court approves a business rescue plan and that business rescue plan is premised on the fact that there will be a funding that comes from Treasury. Has government not breached its obligation in that sense? I heard you saying it's okay. Your word was not suggestive, but it was conditional. It was this and this. But the business rescue plan, as adopted by the creditors, as codified by the court order that was placing SAPO into business rescue, clearly anticipates that 3.8 billion rand being paid in full. So how is it that anybody, whether it is government or anybody else, can go to court, say it is on this basis that we are going to get this institution out of the situation it's in, we're going to turn it around, creditors will be paid, and so forth, and then they just renege? Maybe just to hold your answer to that while I take Honorable Bodlani. Honorable Bodlani.
I was raising my hand to say I want to speak last, but now that we are here.
Well, you're last. You're coming after me and there's no other hands. Okay, Ms. Singh has her hand up.
What I have, which is a similar question to what you have just asked, and in my little mind, I want to talk about breach of promise, because we used to hear about those when people had promised to marry others and they would walk away from that commitment. And it is, perhaps let me phrase it this way, to say, what recourse does the BRPs have? Because they come in as joint business rescue practitioners with the understanding that government has made a commitment to the 2.4 and the 3.8. And this is why they take on the rescue process, which obviously they attach their names to as business rescue practitioners, and they plan around the second tranche coming. And it would, for me, it would say if government gave the 2.4, then they would have been absolutely sure that the 3.8 would have come. And considering that the issue of the 3.8 not forthcoming was only heard with the minister saying he is providing tough love. And I don't know if there has been formal communication to the BRPs from the minister enforcing the issue of tough love. If there is, we have not been privy to that. But it is just to say, for them, what recourse do they have? Because they obviously took on the job with the expectation that there would be that. And if cabinet releases a statement, it must hold some water. It do we know what? Sorry, my dog just came in. A cabinet statement is it clearly not enough for the BRPs to go on? So I think it would really have been nice for the legal opinion to go further into that in terms of what obligation government has after issuing a cabinet statement. And again, I'm not sure if the National Treasury has officially communicated that the 3.8 billion is coming, because that again leaves the BRPs in limbo, whether they, in terms of not knowing they must file for liquidation, exit the rescue, on what grounds would they exit the rescues. And I'm just making a comment. I'm not necessarily asking for a reply on that. Was there any undertaking has alternative funding? Okay, I think those are my questions and comments, and perhaps it just to broaden the conversation and allow you, Ms. Arnott, to really go further in terms of the explanations that you have given. Thank you so much, Chair.
Thank you very much, Honorable Singh.
Thank you, Chair. I think we all pretty much have the same question on our mind, and that is, whether this 3.8 billion now was a firm commitment or not. So I think just touching on what the Honorable Bodlani said, I would also like to know, in the presentation we were told that it was made clear at the outset that the 3.8 billion was subject to an approval process. So whilst that funds was not made available in October 2024, I would just like to know also, what was that actual approval process? How did it take place? And then was it actually now not approved on some ground? I think that's important for us to know. The fact that the minister said it was tough love and did not allocate those funds in October 2024 is one thing. But there would have had to be, I'm assuming, that if there was an approval process that was supposed to put in place. Secondly, what is also concerning is that if the 3.8 billion was subject to an approval process, how the whole plan was actually approved. Because if it was subject to an approval process, then in actual fact, there was no firm commitment for that 3.8 billion. So various people may have made various statements at various times, but what this legal opinion is telling us, if it is indeed so, is that there was no actual commitment made for this. It was subject to this approval process, and then it was not approved. So I think it's critically important just to figure out what happened about that approval process. And like I said, I'm not so sure without that firm commitment, because there were conditions obviously attached to that, because they had to try and get approval at the time for the second tranche, how that plan then was actually approved in the first place. Thank you, Chair.
Thank you, Honorable Singh. Honorable Subrathi.
Thank you, Chair. Chair, I will continue to remain off the camera, Chair, if you don't mind, please.
No problem. You may continue.
Thank you, Chair. Chair, the legal opinion states that 3.8 billion commitment cannot be regarded as creating, and I quote, legal liability, unquote, and describes it as tentative, provisional, or conditional. However, Chair, the BRP explicitly states that the BRPs anticipate that the approval process for the allocation of the 3.8 billion will be finalized during the course of 2024. Now, this is what the BRP had stated. And the North Gauteng High Court judgment records this commitment. Someone needs to explain why these commitments made in court papers and the adopted business rescue plan should not be considered binding obligations by the department. And maybe what message does this send out about the reliability of government commitments made during these court proceedings? My second reflection and comment and maybe question would be that the legal opinion indicates that National Treasury requires, and I quote, a solid business plan, unquote, before releasing the 3.8 billion. Now, given that the BRP was adopted in December 23 and contains detailed financial projections for 3 years, infrastructure investment plans totaling 2.75 billion, operational restructuring proposals, and specific allocations for every rand of the 3.8 billion across 85 pages. What additional business planning does Treasury require beyond what is already contained in this comprehensive adopted BRP? And why was this requirement maybe not communicated as a precondition before that commitment was made? Chairperson, maybe, and a further question is, and I think my colleagues have covered me about, okay, the BRP proposes several regulatory changes, including amendments to the first and second street addresses protocols to allow delivery to post boxes rather than street addresses, and transversing certain SAPO branches to post by nearly 2 years have passed. Maybe what legislative amendments have been proposed by stakeholders in this call? I suppose, Honorable Bodlani, and you have ruled that the post office can't respond to this question here, but I would have wanted to have known what the stakeholders in this call have proposed have regarded as necessary to implement the BRP. But I think I'll pause on that question. Chairperson, so those will be my 2 substantive questions surrounding the business plan that is being spoken about, that is required as per the legal opinion. And then the notion that the 3.8 billion, what message are we sending about the reliability of government's commitments made during these court proceedings? Thank you, Chairperson. Maybe as a reflection, maybe we need to then haul in the Minister Treasury to a meeting like this to explain themselves. Thank you, Chairperson.
Thank you. Thank you very much, Honorable Subrathi. Honorable Alicia?
Thank you very much, Chair. So, Chairperson, the minister, I suppose not this one because this happened in 2023. We learned that the minister went to court and swore under oath that cabinet had pledged the 3.8 billion, right, to save the post office. Now we have the National Treasury refusing this funding. So I want to understand where that sworn affidavit stands now. Was it misleading? And maybe, so you see, the legal opinion states that, you know, this issue of commitment, it was non-committal. Is this now how this government operates, you know, going out there and making grand public announcements just to soothe us as the public while having no intention? Because clearly then there was never an intentional plan to follow through. That's what I'm thinking. What does it mean when you have a minister who goes to court and swear under oath, you know, that the cabinet had pledged this amount of money to do this, and you only find out that it was just a grand public announcement? What are the consequences to that? And another issue for me, Chair, is that so the business rescue plan, you know, required a retrenchment of workers, and these job losses were supposedly to be offset by this 3.8 billion investment in modernization. Now the investment is cancelled, but the retrenchments will proceed or have proceeded. I don't know, you know. And for me, it means that when people are talking about tough love, when you've got a Minister of Finance talking about tough love, it angers me so much because this is a tough love that is always for Black people, for Black workers, and for small businesses who are creditors, while you've got, you know, this gentle love and bailouts available for, you know, for other people. So I think we need to look at that, Chairperson, because we've got a post office here that owes small and medium businesses, and many of these people are Black-owned, you know, businesses, over like 8 billion, right? And the rescue plan offered them, you know, some sense on rents. Now the funding is gone. What's going to happen? What's going to happen to them? Why do we keep having a government that is comfortable with destroying, like, you know, Black people who are trying for themselves, and there are no consequences at all? I just want to understand that, Chair, and I want us to think about it. And it must be an issue that when we come up with these things and these things don't work through, it always affects our people. It always affects the workers. It always affects these small businesses. And you've got ministers or deputy ministers now that, you know, get away with it without consequences, and they just make these utterances. And now we're faced with a situation where, you know, we don't know what to do because clearly it seems like the money is not there. So I just wanted to raise that, Chairperson, because now, given that the legal opinion, because in my understanding is that the legal opinion finds that there's no binding commitment. So does this mean the future promise by the then minister in an affidavit is worthless? Is that what it means, all in all? Thank you very much, Chair.
Thank you very much, Honorable Alicia. I'm not seeing any more hands. My apologies. I'm not seeing any more hands. So I'm going to hand over to Ms. Arnold Ms. Arnold, can I ask that you respond specifically to some of the legal questions that have been raised? I know that others are more directed at the ministry as well as SAPO itself. But if you could just take us through some of the legal questions, I'm sure you can hear the frustration from members with the situation that the SAPO finds itself. If you're also able to offer any additional remedies over and above what you have said already. Ms. Arnold, over to you. Sorry, is it Advocate Arnold? I do apologize.
No, Honourable Chair, it's just Miss Arnold. Arnold, Adela Arnold. Thank you.
Thank you.
Thank you, Chair. Thank you, honourable members. I think the issue here is the commitment. Now, neither the business rescue plan, the affidavit, the cabinet statement, or the court order makes a promise that you will definitely be getting 3.8 billion rand. The business rescue plan, and this is at page 69, it speaks about the fact that there will have to be an approval process for this 3.8 billion rand. It acknowledges that an application needs to be made. To who is this application made? The application is made to the Minister of Finance. How does this happen? This happens within the framework of our national budget process. The money needs to be appropriated. It is only the Minister of Finance that has the power to action the appropriation of monies. The initial 2.4 billion rand was appropriated by an act of parliament, but we need to keep in mind that there were conditions attached to that. And it is hence that an application would have to be made for the 3.8 billion rand. I can't speak to the actual application process. I think, and this ties into the question that Chair posed, what else could possibly be done? Possibly speaking to National Treasury to find out more details with regards to this application process. But I'll reiterate that the business rescue plan, the affidavit, the cabinet statement, the court order, all speaks to the fact that an application process will have to be made. There was no, for the lack of a better word, I understand we look at this as a promise or commitment, but there was at no point was it said it will definitely be there. There's always reference to an application process that will have to be made. We need to remember that the MTPPS is the point wherein departments can ask for more money. They can ask for rollovers, adjustments to their budgets. And it is at that point that the 3.8 billion rand would or should have been forthcoming. Thank you, Chair. Thank you, honourable members.
Okay, thank you very much, Ms. Arnold. Honourable members, I think maybe with your concurrence, maybe let us stop it here insofar as the briefing on the legal opinion by Parliamentary Legal Services. I want to propose, but I'll take your suggestions as well. I want to propose that we have an engagement. Well, just recently this week, you would have had an engagement on the quarterly reports of SAPO. But we may have to have an engagement with the business rescue practitioners and the ministry, the department, around the funding of SAPO once again. I can put on record that in numerous interactions that I would have undertaken with the Minister of Finance, also with the chair of the Standing Committee on Appropriations. The one issue that they said is that they are not opposed to funding SAPO, but they felt that SAPO had not fulfilled its conditions. And upon asking what those conditions were, I think members will remember how we kept asking SAPO about what is their sustainability plan beyond this? What are they going to do what's happening with the partnerships and so forth. And the sense that I've always gotten has been the fact that in the event that SAPO is able to present a sustainability plan to National Treasury, and I must commend them for the work that they had started doing around looking for strategic partnerships, then National Treasury would be on board. I would wish to propose that we schedule a meeting where we ask them to come and present on how far that process is, and also to engage once again. It doesn't have to be a joint meeting, but continue engagement with the Standing Committee on Appropriations and any other relevant avenues to ensure that everybody is on board, the same way we've done with the funding model. Everybody is on board with regards to the path that SAPO takes. Perhaps the department would even want to consider writing to the Minister of Finance to ask them to spell out their conditions, because even the interactions that I'm speaking about, there's been no document that I've seen that sets out exactly what the conditions precedent to them getting that 1.4 billion, I think it is, that is outstanding should be. But I'm open to, other views of the honorable members in terms of how you believe that we should take this forward, given this particular legal opinion of Parliament. And I do want to reiterate, an opinion is an opinion. If members are not convinced, what is it that you are proposing you would like us to do moving forward? Honorable Singh, I see your hand. You may proceed.
Thank you, Chair. And in principle, I have no objection to your proposal. I just want to raise a concern in the response that came through, where we were being told that they cannot talk to the process because they can go and look at that now. And I'm just really worried that if they haven't looked at that, then there could be a fatal flaw in this legal opinion that we've been given. Because one would assume that you would probably look at all the facts and find out, because that approval process is the key basis on which you're going to determine whether there was a fixed commitment or not. So I am actually a bit worried. If I have got that wrong, then maybe that could just be explained. But that is a key worry. And the second thing is that if we could have clarity regarding this amount of the 3.8 billion was supposed to, the approval process was meant to be finalized by October 2024. So now that that hasn't been done, and for all intents and purposes, the Minister of Finance did not budget for those funds. Is it still open to a request now being made past that date? Thank you, Chair.
Thank you very much, Honorable Singh. I see you want to respond, Ms. Arnold, but also maybe just as you're responding, just think about, I mean, there's something that's not adding up here, right? How is Treasury imposing conditions if there is no commitment, right? I'm still struggling with this notion of no binding commitment, because we would take it that if our cabinet makes a commitment, it's done a projection on funding, the funding should be available, then you come back and you say these are the conditions for you to access this funding, which we have already committed to you. And for me, that question was not answered in your legal opinion, except to say, appropriation is done at a particular stage. It means that any commitments that they've made at any point, can just be disregarded. But if you could please answer the process question. Let me take Honorable Botlane, and then I'll hand over to you, Ms. Arnold. Honorable Botlane.
Thank you so much, Chair. Chair, I think you raised an important issue that I also raised during the meeting on Tuesday. And I asked the content advisors to please advise us on whether our understanding is correct or not. My little understanding was that as part of the business rescue process, the business rescue practitioners were required to put together a strategic plan, a sustainability plan for the post office. But what I thought in that meeting was that they were only required to put together a plan insofar as paying the creditors. And I think this is where we miss each other, to say, what was the expectation and what is the actual situation? So I maybe have to make the request again to the content advisors so that we speak from a point of empowerment. And I don't think it would be fair to ask this question to Mrs. Arnold, so that we speak to a point from a point of being empowered to say, what is the actual thing that was expected of the business rescue practitioners? Was it a plan in terms of the payment of practitioners, or was it a plan in terms of a strategic plan towards the future of SAPO? If we are clarified on that, I think it will really shape our understanding in terms of how we engage, even with the legal opinion.
Well noted. Thank you, Honorable Botlani. Ms. Arnold, over to you.
Thank you, honorable members. Thank you, Honorable Singh. Perhaps when I said that I would rather not go there, I'm speaking about the specific technical, procedural, practical manner in which National Treasury, the Minister of Finance, considers this application. I wouldn't have knowledge, and I think this is best placed at Treasury's door. Who makes the application? Is the form? Who speaks to who? When is it made? When was it made after the initial tranche of 2.4 billion rand was given? When were and I think this speaks to Chair's question as well. When were the conditions imposed? Was these conditions communicated to the business rescue practitioners? That I don't have knowledge on. That, in my view, would be best answered by the experts, and that would be National Treasury. I don't know if the department perhaps has knowledge on this, or whether SAPO knows whether there was constant communication, or was it just communicated when the MTBPS was announced by the Minister of Finance in October 2024, that this is our policy perspective and the 3.8 billion rand will not be forthcoming. I am uncertain whether that is the end of the road, whether there's a possibility for further engagements, whether SAPO can come forward and say, these are the conditions. Have they received conditions apart from the statement, the policy statement by the Minister of Finance? Have they received conditions? I don't know, Honourable Chairperson, Honourable Members. Thank you.
Okay, thank you very much, Ms. Arnold. Members, let's bring it to a close. So I had made a suggestion which I think has been accepted by the committee, and I would request that the content advisors and the secretariat, prior to scheduling that meeting with the department to get a status check-in, we also dispatch a letter to the Minister of Finance with these pertinent questions that members are raising in terms of the conditions, when they're imposed, what is the implication of them reneging on their commitment that they had made, and hopefully we should have that within a few days so we can schedule this meeting as soon as the program allows. But once again, let me thank the members, just for, being like dogs with a bone on this matter. I don't think that at any point are you trying to get a bailout for SAPO, or you're trying to give them an easy way out. But as much as you exercise oversight over them, I do think that we have a role to assist them in any way that we can, if it means holding other, departments and so forth to account. It is the work of all of us anyway as members of Parliament. With there being no other item on the agenda, I would like to bring the meeting to a close. I'm not seeing any other hands. And I do think in terms of the program next week, that would have been shared with the members. So with your concurrence, honorable members, please may I declare this meeting closed. and also thank Ms. Arnold and the team at Parliamentary Legal Services so much for their engagement and the work that they've put into the opinion. Thank you, honorable members. You enjoy the weekend. It's 10 to 6. It's time for item number 17. Good evening.
Thank you, Chair. Good evening. Have a great weekend.
Good night. Thank you, Chair.
Thank you, Chair.